Good afternoon.
Good afternoon, Your Honor.
You got very fortunate. You're our last one of the day.
So I'm the only thing
Last but not
standing
least.
between you and your well-deserved break.
Well, thank you for joining us here this afternoon. Welcome to Oviedo, welcome to Judah. As
Thank
you know,
you.
I'm Amanda Carl, I'm the vice chair of JNC. You've been in front of us before, so you kind of know our process. Everyone will go around and introduce themselves, tell you where they're from. We'll give you 2 minutes for your opening, then we'll have questioning, and then we'll have a minute at the end if you want to make any closing remarks. One difference today, we do have the camera. Volusia Exposed is here, so you have the camera right behind you. But other than that, it will be the same process as always. David?
Good afternoon, David DeArmas, Kramer Price and DeArmas in Orlando.
Good afternoon, Your Honor. Ben Citro from the law offices of Horowitz and Citro in Orlando.
Andy Bardos with the Gray Robinson Law Firm.
Good afternoon.
Good afternoon, Your Honor. Brett Renton, Orlando, Shutsonville.
Good afternoon.
Good afternoon, Your Honor. Pedro Brownlee with the Brownlee Law Firm.
Good afternoon.
And good afternoon, Craig Dyer, Public Defender's Office, Daytona Beach.
Good afternoon.
Head when you're ready.
Well, first of all, I want to thank all the members of the commission for giving me this opportunity once again to speak with you. The reason I applied for this position, as I have stated in the past, is I do believe that I have a duty to serve the community in a capacity that allows me to best utilize my abilities. I humbly believe that serving on the 5th District Court of Appeal is the position in which I can fulfill that duty. And I hope that after considering my application, talking to the people who have honored me with their support, and responding to your questions here today, that you will share that belief.
Thank you. Your Honor, I had the privilege of conducting your background check and talking to your references, and I will tell you it would take a good chunk of the time that you have to go through the kind of things that Judge Mendoza had said about you and Judge Perry and several others. You were very well regarded by the peers on the bench as well as the lawyers who you listed as references. As hard as I tried, the best I got out of them as far as a strength and a weakness is everybody said that you had this unwavering commitment to getting it right. That without exception, you will always try to get it right. But sometimes that's at the expense of managing the timeliness of your docket, and that was the only concern that was expressed by several individuals. So I was hoping you would touch a bit on your docket management, how you handle it, and how going from a courtroom in trial court where your docket rises and falls with you into a setting where clearly you're relying on colleagues and colleagues are relying on you in order to efficiently manage that docket.
Well, thank you. Well, I'm humbled by the support that I have, and thank you for sharing the positive comments that you obtained when you were looking into my background. With respect to docket management, I believe when you look at the totality of my work on the circuit bench that I have rendered my decisions in a timely manner. There have been occasions where I believe the parties may have thought that the time that it took was longer that they would have liked. I can assure you it is not because of a lack of working hard. I do pride myself on being a hard worker. I work very hard to do what I do, and I do want to get it right. I've taken an oath to uphold the Constitution and the law, and I am not someone that believes that I should just make a decision and leave it to the appellate courts to sort it out. That being said, there is a certain amount of time that I can dedicate to a case that varies on the complexity of the issues. And I think on those occasions where the parties may have thought that I spent more time than I should have, it was because it was a complicated matter. I can think of just really on one hand how many cases where that has occurred, where even I was disappointed and worked even harder, came in weekends to get the research done, but it was only because it was a complicated legal issue. And in the cases that I'm thinking about where I was wishing that I would have been able to get a decision out earlier, it was a non-jury case, and so I was also the finder of fact. However, I think that at the appellate level, and particularly pointing to the same case that I've listed as one of my cases, the volume of cases at the trial level was much, much different than at the appellate level. Also, the support that you have. At the trial level, it's pretty much me. My JA doesn't do legal research. But the scene case, which was extremely complicated, dealing with election law, which I had never dealt with before, once I was given, by the good grace of Chief Judge Lawton, a dedicated law clerk for that case, we turned that case around quickly, including a very lengthy and detailed written, which I submitted as my writing sample. And so I believe that is really more of a reflection of how I would deal with at the appellate level, because I worked with Ms. Batakis as I would a law clerk at the 5th District Court of Appeal.
What is the longest you've taken as a judge to rule on a motion or a trial?
I believe the absolute longest, and I will say, I don't want to give you misinformation.
Sure.
So going by memory, I think it was probably in the neighborhood of 6 to 9 months. That was a non-jury eminent domain case, 5 days of trial. Again, novel issues that I was not familiar with as a judge or as private practice. Involved a statute regarding citrus and new regulations that came in that required certain protective coverings over these plants, and if they weren't protected, they were to be destroyed. Very, very, very excellent attorneys, but complex legal issues, claims on the plaintiff's side in the millions of dollars. Obviously, the Department of Agriculture, having a very substantial interest that they were advocating, wanted to get it right. Time will tell whether I got it right, because I just ruled on the taking issue, and the compensation issue was going to be determined by jury trial. One of the most fascinating cases I dealt with, I did not have clerk support for that. I relied on the attorneys, had significant hearings with them, gave them oral argument opportunities.
Sure. And so one of the things we've learned from your colleagues is that we understand you have to file a report about any cases that you're pending for longer than 60 days. Is that the only case that you had to file something about, or?
There is a reporting, which I believe my JA dealt with that issue.
Okay.
I didn't track the reporting.
Not a problem. Turning to, let me ask you this question.
And to be clear, that was the longest case that you had
Sure.
asked about. I believe there may have been a handful of cases that were over the 60 days, which would be the reporting requirement. Whether those reports would reflect that, I don't know, but
Okay.
there were.
Sure. Do you believe that when we're going to send up the names of individuals to the governor to go ahead and make a decision, do you believe that as a pretty rigid rule, we should insist that those individuals have judicial experience in their background in order to be on the 5th District Court of Appeal?
As a rigid rule, I would say no.
And why?
Well, as a preface, I do believe that as a general rule, it is better to have trial judge experience. I remember Justice Lawson mentioning that in one of his interviews, I believe, with the Florida Supreme Court Nominating Commission. I agree with that. Having served as a judge now, I did apply. The first time I applied for the 5th District Court of Appeal, I was a practicing attorney in 2006. Now, I'm glad that I was not selected and that I've waited to develop the expertise that I've developed on the bench. That being said, there are attorneys who have done an outstanding job, Judge Palmer among them. who was a practicing attorney, never a judge, but nevertheless had a very distinguished career on the Fifth District Court of Appeals. So I don't believe it's an absolute rule.
Okay. And what do you think is the largest challenge to the court system being able to maintain its independence or its integrity?
I believe the biggest challenge that the judiciary faces is from itself.
What does that mean?
Judges
Okay.
have the ability to, they're the ones that are making a decision. So when a judge makes that decision, he or she really needs to think about, in my view, the proper role of courts and the separation of powers and everything that is engrafted in our Constitution. Florida has an even more stringent separation of powers requirement than the U.S. Constitution. It's expressed. And then interpreting the text, going by what it says, that is the way I believe that the courts maintain a high level of confidence in the public, which is essential to any branch of government, having vitality going forward. And so I think it really is within our power as judges to do that. I think we need to do a better job of doing that, because I think our perception of the public has been eroded to a certain extent by certain opinions that don't, I believe, confine judicial authority within its proper limits.
I was going to say, can you tell me
Yeah.
what? Yeah.
I'm with you, go ahead.
Yeah. Can you explain that a little bit in terms of what specifically you're referring to?
Well, in terms of decisions,
Yeah.
the most recent decision that comes to mind is the decision on Dalbert. Again, the Florida Supreme Court has certain jurisdictional authority. I agree with the dissent that that was a decision that should not have been rendered at all, and set aside the merits for another day. Because that is the structure that the people of this state have set up, that it's a limited court, a limited jurisdiction, the courts of last resort are the district courts of appeal, and unless there's a valid basis for jurisdiction, the Supreme Court shouldn't be weighing in, with all due respect to members of the majority. And I think at the United States level, there have been decisions juvenile sentencing, for example, and I'm seeing the reality of that on a daily basis.
You think that they are misapplying the law with juvenile sentencing?
Correct.
Can you expound upon it? I'm not.
The court has found that under the Eighth Amendment, it violates the Eighth Amendment.
Oh, like Miller.
To Miller and Graham.
Gotcha.
Correct.
Oh, and you think Miller and Graham were decided incorrectly?
Correct.
You think?
I think that is a matter for the legislatures, and I'm very confident that many of the sovereign states of this country would render essentially by legislative enactment the holdings of Miller and Graham. The juveniles should be treated differently, that they cannot be, that it's not a mandatory life sentence, and I think that's fine if that's what the sovereign citizens of the states that through their legislative and executive branches, not the courts, decide that that's the best policy. And there are legitimate policy arguments for it. But to read a court opinion and to see those policy arguments in the pages of a judicial opinion by a handful of lawyers is disturbing to me.
So then, where do you think that, particularly with something like the Eighth Amendment, I mean, I think that there are a lot of broad constitutional amendments that, well, I won't lead you. Where do you think stare decisis fits in with the rule of law analysis?
I do believe, my philosophy is such that the reason that the law, one of the reasons the law is there is to help people govern their conduct. And I think that that is a concern when there has been a legal decision that the people, the citizens of the state or the nation, whatever is applicable, be able to rely upon that. However, I think stare decisis is less weighty of a factor when you're dealing with a constitutional issue, as opposed to a statutory interpretation. Because once the statute is interpreted by the courts, then there's a principle that if the legislature takes no action, that they essentially approve it. I don't know how valid that is, but that is a principle, and there is, I think, some merit to that. But if it's a constitutional interpretation, there's nothing the legislature can do about it. And so, I believe there, stare decisis does not prevent a court from, if there's been an incorrect interpretation of the Constitution, from changing that. Because if it's not a correct constitutional decision, that is tyranny.
So then, what if you were selected for this position, and say you got an appeal from the denial of well, you wouldn't get a grant, but imagine some way that I can't come up with right now that you would be faced with a Miller issue on the 5th, and you're faced with, okay, do I follow Miller or do I not follow Miller, or Graham? But I mean, Miller's more recent, so
Well,
how would you handle that?
as a member of the 5th District Court of Appeal, well, because everything I just articulated is what I believe from a judicial philosophy, how judges should be bound by the oath that they take. But if I take an oath as a 5th District Court of Appeal judge, then I'm also taking an oath to be subservient to higher courts. And so I don't believe it would be my place as a 5th District Court of Appeal judge to decide that I am a one-person U.S. Supreme Court or a Florida Supreme Court. I would probably, if I can't find a way that's intellectually honest to distinguish Miller and Graham, which I would look at that. That's legitimate if it can be distinguished. But if I can't, then I would probably specially concur and say, this is the law. As I understand it, I think it's incorrect. I urge our Florida Supreme Court to revisit it, or if necessary, take it up to the United States Supreme Court for reconsideration.
We have time for one more question, if there's one more. Okay, well, if you'd like to make some closing remarks, please feel free.
Well, again, I just want to thank you again for this opportunity. Enjoyed our time together. Enjoyed these questions. It's one of the more active and engaging discussions I've had in a while. So I do appreciate it. I know you have a very difficult job, particularly this time. I know you all have a very, very hard job to do, always going through these applications, but with the holidays and everything being very compressed. Again, I just want to thank you for taking the time away from your families to be here to interview all of us. I do think that we went into my philosophy, I think, in more detail than I had expected, so I won't repeat that. I think that should be pretty clear. I will also say this, I think my background with being on the city council, my engineering background, my trial court background, my background as attorney, I do believe I have a unique set of abilities and experiences that make me different than the other candidates. I'm not saying that's better or worse, but I think it is different. I would point out, half serious and half light, that Judge Torpy is the only University of Central Florida graduate on the 5th District Court of Appeal.
So this would make sense.
So far.
I think that is something also to consider, since that is the only university within the 5th District's geographical limits. It's part of the state. Little plug for my Knights.
I will tell you, one of your references who knew the list said he was going to be impressed if we came up with more than a list of one with just your name on it. So.
Well, again, so I do appreciate your time. I know you have a difficult job to do, and I know that I'm the last interview, so I will certainly let you get to it, and hope you all have a good weekend.
Thank
Thank
you.
you. Happy New Year.
Happy New Year.
Happy New Year.
Thank you.